Good evening to one and all present here. It is my pleasure to welcome you to today's online lecture on patentability standards, critical analysis of the NUNs test. We are pleased to welcome our guest lecturer today, Ms. Richa Prajapati, Assistant Professor at School of Law, MS Ramaya University of Applied Sciences in Bangalore. Without any further delay, I shall request Ms. Prajapati to kindly proceed with the session. We are facing a slight technicality issue from our end. We'll begin shortly. Ms. Prajapati, can you hear us? Are you here with us?
Yes, I'm here. Am I
Okay.
audible clearly?
Yes, yes, we can hear you clearly.
Okay.
Ma'am, we have already introduced you. You can now start with your lecture.
Okay. Thank you, Shreya. I would like to thank CSR, IPR, NUSRL for this opportunity. And without wasting any time, I will just dive right in. My topic of discussion is standards of patentability. I will analyze the jurisprudence of the NUNs test. Okay. So let me present. Right. So patentability standards, a critical analysis of the NUNs test. This is my topic for discussion. As we know that patents are granted for inventions. So what are inventions? Inventions means it may be a new product or a new process. It must involve an inventive step and it should be capable of industrial application. This is a general definition and it is also a definition given by our Patent Act of 1970. Okay. So invention is a product that has to be new. So first, from this new inventive step and capable of industrial application words, we deduce the test of novelty, utility, and non-obviousness, which is called the NUNs test. Okay. Now first let's discuss what is the test of novelty. Novelty means newness. Something which is new is called novel. As per the patent law, the test of novelty is passed when a product, a claimed invention, is not anticipated, or when it is not used in public, or when it does not form part of the prior art. Not used in public means it does not mean that it has to be used by the public. Not used in public means it has not been used in the public manner, openly, without hiding. Then it will such a use will defeat the test of novelty for a claimed invention. Okay. And this is the prior art, the state of the art. It causes anticipation. So we'll see what is actually prior art. Indian Patent Act uses the word state of the art. So prior art is any literature that is available in the field of the invention. Suppose it is a medical invention. So in the field of pharmacy, in the field of medicine, whatever literature is available can be said to be prior art. But there is a huge literature. So will all of that literature should be called a prior art? All the prior inventions that have come before the claimed invention, should they all be called prior art for the purpose of testing the test of novelty? So the answer is no. The whole literature is not prior art. When we test novelty of a claimed invention, we look at those publicly available information and we take them apart. So one prior art, if it contains all the features of the claimed invention of the applicant, or if not all, then at least all of the essential elements of the claimed invention of the applicant, then we say that the claimed invention is not novel, because whatever are the claims in that invention are already given in one prior art. Okay, so, and such prior art should be so full and so substantial and must contain the information in such clear terms that any person who is not inventive, who is just ordinarily skilled in the given art, they, by looking at this piece of prior art, they can recreate the claimed invention without even looking at the claimed invention. So such piece of literature will form part of the prior art. And if the claimed invention can be found to be completely constituted within one piece of prior art, then we'll say that this claimed invention is not novel and the test of novelty is failed. Second aspect is anticipation. Now, how do we determine whether a claimed invention can be or could have been anticipated by others or not? For that, we take a step by step approach. First, we see, after all, what is the claimed invention. We interpret what the applicant means by presenting his claimed invention. Then, we compare that claim to the existing prior art. And as I have already said, if the whole claim could have been found within single prior source of literature, then we'll say that the people who are ordinarily skilled in that art could have anticipated easily, could have anticipated the claim, the invention that the applicant has come up with. But if the invention, the claimed invention, its elements can be found not in single prior source but in different various prior sources, so we'll have to read all those prior sources and then collectively we'll be able to say, okay, now all the elements are there. But in such a case, we will not be able to say that a person ordinarily skilled in that art could have anticipated the claimed invention. So, in order to pass the anticipation test, what is important is that all the elements of the claimed invention should not be found in one single prior source. They could be found in different sources, fragmented. Then the anticipation test will not be, the novelty test will not be failed. In this regard, a test of reverse infringement was developed by the Australian courts. What is infringement? See, patent is a monopoly right. Okay. Monopoly means that patent holder is exclusively has the rights to use his invention, to make his invention, and to sell his invention. No third person is authorized to do the same. If any third person makes, sells, or uses the invention or a similar, essentially similar thing, then he is liable for infringement of the patent holder's rights. Okay, this is what happens in real life infringement cases. In the test of reverse infringement, we assume that suppose if we grant the patent to the applicant, after that, what happens? After that, if a person who is non inventive and is unaware of this claimed invention, of this patent, he looks at the prior art. And just by looking at the prior art and observing it and studying it, he is able to come up with something, he is able to come up with a product which is so similar, so essentially similar to our patented product that it will amount to infringement. And if that is the case, then since it is so similar to the patented product and it is based on the prior art, we can imply that the patented product is also entirely dependent based on the prior art. And that is why it is not novel. So this test was laid down in this Myers Taylor Limited versus Wicker Industries by an Australian court. Okay. Now, this case Smith versus Snow. What happened in this case was Smith came up with a process. He claimed patent for a process for staged incubation with a flow of air, hot air current to transfer heat amongst eggs in different stages of incubation. Now, before Smith, there had been various efforts to set eggs in staged incubation, but there was no success because of the difficulties of securing adequate heat distribution within the incubator. There were certain prior references. There was one German patent also, and one piece of literature available. And after that, after 1777, it was not even used. Okay, so the court said that such rudimentary experiments with isolated elements of our applicant's combination, they could not anticipate his invention. So, from the facts, you can deduce that in the past, nobody could have anticipated that we should build something that will flow a hot air current in the incubator. They only used hot water pipes and nothing else was used, and that is why it was failing. It was not successful. But Smith finally came up with an invention which was successful. So we will not say it was anticipated because there were already failed attempts made by others. They none of them used this air current technology. Smith did it, so he obviously did something different. So his idea was novel. It was not anticipated. Now let's move on to the next test, the test of non-obviousness. Our Indian Patent Act, it says that an invention must involve the inventive step. Inventive step means that feature of the invention which involves technical advancement or economic significance. And along with this, it also has to not be obvious to a person who is skilled in the art. Who is a person skilled in the art? That is the question. A person skilled in the art means a person who is ordinarily skilled and not an inventive person. He has the knowledge of the art. He has some skills. For example, if he is a doctor, he has knowledge of surgery, he has knowledge of his area of medicine, and he can successfully treat his patients. He is a skilled person. But he may not be inventive. He may not be able to come up with new technologies. Only inventive people can do that. Okay, so inventive steps that are involved in an invention, they are never obvious to an ordinary skilled person. That is the test of non-obviousness. Uh, Basically, we'll see what is technical advancement. Just in brief, I'll say technical advancement basically is a significant improvement or innovation in something, which solves a technical problem. And such solving of the problem, it requires the level of ingenuity and skill which is not required, which is not possessed by an ordinary mechanic, by a person who is at the level of a mechanic, who is acquainted with the business, who is acquainted with the art, but is not inventive. So technical advancements are not just mechanical developments. They solve technical problems. Okay. Now, for non-obviousness also, just like novelty, we have to compare the claimed invention with the prior art. But here, the scope of prior art differs from what we saw in the test of novelty. What happened in novelty was we compared the claimed invention with one single piece of literature or with one single prior invention. So we compared it with the one single prior art. And the test was that all the elements or all the essential elements of the claimed invention must be found in one single prior art. But that is not the case for the test of non-obviousness. It is a more rigorous test, a more stringent test. For this, we look at the whole literature available, the whole prior inventions, and recent developments in that field, which collectively is called the common general knowledge prevalent amongst the community which is engaged in the relevant art. And it's not just pieces of information, it is also that those pieces of information have been widely accepted by this community as valid phenomena or as norms. And a non obvious invention will fall outside of the boundaries of these accepted norms. It would be something different. Okay. Now, in order to test the invention for non obviousness, our MPOPP, the Manual of Patent Office Practice and Procedure of India, they have mentioned 5 steps approach. First is, first we identify who is the this person who is skilled in the art. Then we have to identify what is the common general knowledge possessed by such person or persons. Then we see what is the inventive concept in our applicant's claimed invention. Then we see what are the differences between the claimed invention, between the inventive concept of the claimed invention and the prior art and the common general knowledge. And after all this, we have to make an inquiry. And the inquiry is whether those differences they involved such steps that would have been obvious to the person skilled in the art, or do they require a degree of inventiveness? This is the step-by-step approach of non-obviousness. Now, these steps are actually in line with the Graham test. The Graham test was laid down in 1966 in the Graham versus John Deere case by the US Supreme Court. The 4 of these elements you will see are same as the MPOPP, as the steps given by MPOPP, except the last one. Last one is the objective evidence of non-obviousness, which is commercial success, long felt unsolved needs, and failure of others. So, apart from examining the person skilled in the art, I will call it PCTA, and the inventive concept of the claim and the difference between them, we also can examine what is the commercial success of this invention. Was there a need, long felt need for such an invention? It was unresolved till now. And whether prior attempts were made by others and they have been failing. But these are secondary considerations for the test of non obviousness. Nevertheless, they are the considerations. We can look at them. But why? Why did the court give such secondary considerations? Why should commercial success of an invention be relevant to determine whether it was scientific, it was non-obvious or not? It may not have been inventive, but still it was commercially successful. That is possible for some other reasons, for like marketing, advertising. There are a number of these reasons why a product goes successful, even though it was not worthy of being called an invention. But there is a rationale behind it. So, in this case of Haberman, the court said that we need to consider some things, which is the rationale of commercial argument. The court said first, we'll see what was the problem. There must have been a problem which this claimed invention now seeks to solve, and that for how long that problem has been prevailing. If it was a long-standing problem, then it is significant. It's irrelevant. There was a need to solve it. That is why the claimed invention was needed. And as soon as it came in the market, it was commercially successful. We can ask these questions. How widely known was the problem and how many persons were seeking solutions to it? Again, if No, not many people were bothered or affected by that problem, and not many people were seeking solutions to this problem, then the claimed invention would not be successful, because they would not want this invention, because they were not bothered that much by the problem. And if prior to this claimed invention some solutions were given by other people previously, were they not successful, and what was the reason for their failure? Was there a financial constraint? Was it too difficult to manufacture those products? It was inviable, economically inviable, or for some other reason inviable. But this claimed invention that our applicant has come up with, it does not have those restraints. It does not have those constraints. It can be easily manufactured. It is economically viable, and it solves the long-standing problem. That is why it's going commercially successful. Those questions can be asked. Now in this case, Parks Kramer company, what happened was, there was an invention, and it was a method of only cleaning floors. Very simple. It was an invention, a method of cleaning floors between rows of textile machines. But there had been many attempts to find a satisfactory solution to it, but none of them actually worked. None of them worked like this claimed invention actually worked. What was this invention? There was an overhead vacuum cleaner which moved automatically up and down the rows between those machines. And attached to the cleaners, there were vertical long cubes. They reached almost to the floor. This was the product, this was the invention. The trial court said it was a very obvious invention. Any housewife could come up with such an idea, right? That a vacuum cleaner can clean dust. Everybody knows that. But the Court of Appeal said that many unsuccessful attempts were made by inventors, not by housewives, by inventors themselves to find a solution. But they could not do that. And the immediate commercial success of this invention that our applicant has come up with, it has denied the possibility of finding obviousness. His invention was not obvious. Another, apart from Gram test, there is this TSM principle, which is a little controversial. It says that the test is about teaching, suggestion, and motivation. It's a pretty narrow test. So it means that when analyzing the obviousness of an invention, while comparing it with prior art, there are three questions that we have to ask. Whether the prior art is instrumental in teaching its readers the method of producing an invention, or whether the prior art suggests any method of producing the invention, a specific suggestion, or whether the prior art talk about the problems that are related to a particular technology which motivate an invention in a particular manner. This is the TSM principle. But it is a pretty controversial principle. Many academicians believe that this principle has been discontinued. We don't follow this principle anymore to determine non-obviousness of a claimed invention. Because of this case, the KSR International Company versus Teleflex, it criticized the TSM principle by saying that although it may give helpful insights, but it's kind of very rigid, and the obviousness analysis cannot be confined to a formalistic conception of the words that are teaching, suggestion, and motivation. It overemphasizes the importance of published material and ignores all other prior arts. There is a diversity of inventive pursuits, and modern technology, it suggests, against limiting this analysis. By applying TSM principle, we actually limit our analysis of non-obviousness. It is possible that some obvious things, some obvious techniques are not even discussed in the community, and that's why nobody writes about them or publishes them. What will happen in such a case? If we cannot find a literature on a topic and a claimed invention, and then we compare the claimed invention with the prior art which is non-existing now, we'll say it is it's non-obvious, but that will lead to retardation of growth. Why? Because it will lead to patenting obvious things, existing obvious knowledge. If somebody gets a monopoly over existing obvious knowledge, other people will not be able to use it, although it is in public domain, which goes against our IP laws, IP principles. That's what the court said. But the court also said that the TSM principle does provide helpful insights. The problem is that the courts may tend to apply this principle rigidly. Courts have to be wary of not applying it rigidly. Courts have to be wary that there are other tests also. So pay attention to all of them and not to this principle alone. Take its help, but not make it a mandatory requirement. That is the current situation. It's not that legally it is discontinued. Because if you see the USPTO, the US Patent Office website, they mention 7 criteria of patentability. And TSM principle is one of them, still one of them. Now, next we'll see the last test, which is the test of utility. Utility means usefulness of something. But is it that simple? Is the utility mean only usefulness? The thing is that in patent law, when we talk about patent law, then utility means something else. It's not just plain usefulness. It is used in a context and in a very special sense. A mere useful is not sufficient to grant patent to a claimed invention. In Brenner versus Manson, it's a very important case. In this case, the court came up with the test of specific and substantial utility. Specific and substantial utility. Why? Because an invention whose utility, why that invention is there, why has the applicant come up with an invention, what is the problem that that invention is seeking to solve, if that is not clear, then what happens? It is basically, if patent is granted, then it becomes a monopoly over the knowledge itself and not the product that the claimant has come up with, because the product that he has come up with does not really have a specific utility. What are you going to use it for? Then what happens? You granted a patent. Now you have granted a patent not on a product that can be used for a certain purpose, but on the knowledge which is used in making that product. And knowledge cannot be monopolized. That is why test of utility has to be applied. Our MPOPP, it says that specific utility should be indicated when an application is filed along with specifications. Merely saying that my claim has utility is not enough. The claimant has to specify what is the utility. For example, my drug is going to cure blood cancer with, and these side effects that existed in prior drugs are done away with. This is quite specific. So such specific utility must be mentioned in the specifications by the applicant. Because there is a famous statement in the Brenner versus Manson itself, it is said, patent is not a hunting license. Patent does not give you permission to go hunt, search for answers. It is a reward, it is a compensation for a successful conclusion of your search. After conducting all your search and research, you must come up with a final product, or an intermediate, at least an intermediate product, which solves a problem, an existing problem, which has some utility in public. If that is not the case, then since it would amount to monopolizing knowledge, patent cannot be granted. In Indian law, if you see, Section 21AC does not use the term utility. It uses the word capable of industrial application. So, an invention can be patented only if it is capable of industrial application. What does that mean? Capable of industrial application means that product must be capable of being produced in an industry at a large level, or it must be capable of being used in an industry at a large level to produce something else. If it is having utility but it cannot be applied in industries, then unfortunately patent cannot be granted in India. And this usage of words of capable of industrial application makes the Indian law on utility, the standards of patentability, a little higher than, say, US or EU. So that was it for my discussion. I hope I have been able to clarify the concepts of the jurisprudence of the NUNs test. If there are any questions, you can ask me.
We would like to conclude today's session. I would like to extend a heartfelt gratitude to Ms. Richa Prajapati for sharing her knowledge and insights with us today. A special thank you to the organizing team, whose efforts behind the scenes made this lecture possible and seamless. Once again, thank you all for joining us, and we look forward to seeing you at our future events.
Thank you, Hitashi.